Okay, I've got 9 o'clock. If y'all would stand for the pledge and prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Dear Heavenly Father, be with us today as we do business in Mills County. Guide us and direct us and do what's good for Mills County as a whole. Bless this rain, bless our country with some rain.
Amen. Okay, Mills County Commissioners Court for a special meeting of November 16th, 2020 is in session. Present in the courtroom, we have Commissioner Wright, Commissioner Hall, Commissioner Guerin, and Commissioner Williams. So it's 100% of Commissioners Court is present, and we are duly convened. We also have present in the courtroom County Clerk Sonia Scott. We have audience in the courtroom. I can't see everybody. Dale Parton, Ray Cohen, and Jed Johnson, and there's Dudley. Okay, the mask throws me in. Present via Zoom, our attorney, Jeff Allen from Sweetwater, and at the Law Enforcement Center, Tina Allensworth, and I believe that's Chris Green with her. So, and then Jackie Brooks is running the audiovisual from downstairs. And the Goldthwait Eagle is attending with the bag over the camera. So we are convened. Item 2 on the, what I don't see is our treasurer. And so let's pass on the budget amendment for now. We can come back to it. I believe Jason and I can probably explain it, but we'll wait and see if Trina shows up. Ms. Scott, did we have, any of the audience sign up to speak? Okay. Thank you. Mr. Cohen, would you like to address the court now on the abatement matter or when we get to it on the agenda? Okay. So then item 3 is canvass of votes from the November 3rd, 2020 general election. I ask Ms. Scott to give us an overview of what exactly our obligations are here. And so there'll be a little bit to listen to.
So I have a report, but considering the number of pages that it was, I was glad to hand it out to you, but I didn't want to print 6 of these. It tells you that 7 out of 7 are precincts reported correctly. We did a partial manual recount on Friday, and our partial manual recount was at 100%. So whatever the machine says we voted, we actually physically opened up the ballot box and counted to make sure that they match. The Secretary of State told us which races to count, which precincts to count. There's a audit process when the ballots come back in. We send out 206 ballots to X precinct when they come back in. How many of them were voted? How many of the ballots were spoiled? And our audit was at 100%. The 1 day of early voting, we were off by 1. But in a positive way, our canvas was accurate. Our audit was good. We had 73% of our registered voters voted. And once Commissioners Court accepts the findings, then we can enter the final tabulation numbers into the Secretary of State.
Are there any disputed ballots?
No. We have an early voting ballot board that met twice. They were the mail-in ballots. And there's a specific set of instructions for the early voting ballot board. If you vote by mail, there's a specific set of instructions you have to sign the back of your envelope. You have to, the signatures have to match. And you rejected, I think, around.
I'm sorry to interrupt, but we're having a hard time hearing.
9 that were rejected were because they didn't follow the instructions or the signature. And then they make a decision and they have to notify the voter of why their ballot was rejected. And we have received a couple of calls on that. But again, it's a board decision. It was a unanimous decision. And I stand by the board. I think they did a good job. We did, everyone. Thank you.
So what you need from us is a formal acceptance of the canvassing.
Correct.
I move acceptance of the canvassing of the votes for the November 3rd, 2020 general election. I'll second. The motion is second. Any further discussion? All in favor, say aye. Aye. Any opposed? Thank you.
Thank you.
Okay, number 5. Number 4, consider act interlocal agreement, regional public defender's office. We've seen this for, this in the past has been Lubbock County Public Defender's Office that we have maintained for years an agreement with.
Judge, I'm sorry, sir, but we can't hear you.
We have in the past maintained a interlocal agreement with the Lubbock County Public Defender's Office to provide defense services in the event of a capital murder case in Mills County. It's a small charge that we pay. It's based on our population, and it is insurance against the potentially catastrophic charge of public defense in the event of capital murder. And it's been, not been able to track back the last time we had one of these trials in Mills County, but fortunately it is not frequent. Anyway, what has happened is Lubbock County has spun off this function into a local government corporation called the Public Defender Office Local Government Corporation. So that is the change. The coverage and the concept and the cost sharing is the same. There should be a page in there showing what what our proportionate charge is. Let me find it. It's $1,000, and you know that other counties just eyeballing it. Their rates, we're very much on the low end, runs up to $50,000 or more in some counties. Almost every county in Texas that doesn't have its own public defender's office participates in this program. So that is is what's changed here, and be glad to answer any questions.
Yeah.
Hmm.
They must have had more capital murder cases than we had.
There's one on the books now, I believe.
Yes, there is. Yeah, and it's a multiple, I think. Yeah. Yeah. Well, I would move approval of interlocal agreement with the Regional Public Defender Office, a local government corporation for public defender services in capital murder trials. Okay, is there a second?
Second.
We have a motion, a second. Any further discussion? All in favor, say aye. Aye. Any opposed? Thank you. Five, consider an act on road use agreement. I believe Mr. Guerin has been taking the lead on this and talking with this involved. Are we ready to discuss or take any action here? Yeah,
That's what they're wanting us to do. I visited with Dale a couple of times and Robert, and visited with Jason a little bit on this too. I hadn't run into Mike. They scratched off on the one they sent back to us on the 24-inch 10 horns. My understanding from them was they thought we wanted to replace every 10 horn on all the roads. And I told them, no, this is the ones they damage or destroy during the operation. We want them replaced. And I still think we ought to go with the 24-inch minimum on those horns. We had down the 4 inches of crushed base on all the roads they used. They've said that's more than they think they can afford. And I think investing with the other guys, we ought to change that to all designated heavy haul roads to have 4 inches of aggregate applied to the surface after completion of the construction phase of the project. Just on the ones that are going to run the big equipment over. And that's what we talked about. So whatever, that's up to y'all, whatever you think.
I think it's up to you. I mean, working in those precincts, they damage your roads. I think you are to have the right to say what they need to put on. Have you ran it by with Gerald on the road agreement? Has he looked at it? But he's aware of it. Do you feel comfortable with them, Jed, talking with them and doing everything? He's a private citizen. It's not on the court on it.
So the county roads that are listed, that are redlined, are those being taken off or they've been added?
They've been added.
yeah.
134 is not even in the project.
Oh, okay. So they're gonna use the first, 100 yards of it?
They won't even use that. They'll come out on the highway and turn. Go in.
That's when they're turning in, right?
Not really.
Robert, how do you feel about it? It's in your precinct.
I'm okay with it. And I agree with Jed about the roads that they travel with the heavy equipment. They need to be repaired.
They're gonna have lots of heavy equipment. I'm
It's,
sure.
the majority of it's gonna come off Highway 16, probably. I know some of it's gonna come off the Carrion Highway probably, but I don't know how they're gonna make them turns there in Carrion.
Yeah, I would say that.
That's gonna be a major problem. They can't come up Dale Parton's Road 242 because their dead curves there unless they take part of his land out. And I don't know how that will happen. I don't know.
Did they do that on yours? Did they take some of the corners out?
They dealt 100% with the landowners. The county didn't deal with any of the landowners.
None of that. They
And
won't have
it wasn't, I wasn't worried about what they did with the landowners, whether you put double gates in and took the fences down. All, as far as I know, all the landowners were quite satisfied the way it was taken care of.
The way it looks to me that my county road or will be Dale at the time is 262 around their laydown yard. Will probably be used as much as any road.
Is there any real major tin horns that are pretty good size on
Yes.
any of these roads? Because they did crush one of mine that
There is
it was
one,
36 inch.
there is one box culvert that's about a full eight. That is back in, probably in the seventies, was put in. So you can imagine what it's deteriorated. We'll repair holes on both ends of it before. I don't know how much that's gonna stand up to all of that. So,
According to the agreement, we've got that stuff is in to replace or, you know, anything they tear up like.
Yeah, that's the way I'll see it, so. I just,
surely
but
they looked at it. Surely they've driven that road.
Have, to the best of your knowledge, have they done any physical inspection of the roads? No, okay.
they never do any on mine either, Jed, until the project started and they got with me and we drove every road out. And at that time, they kind of explained how they were gonna use it.
Robinson, I told him that we highly suggested he get somebody down here to look at them, go over them with us where we could tell exactly, you know, what they were talking about. And he said they were waiting on the road agreement and they'd send somebody down within the week. Right.
Right, but we're going to cross default this with the tax abatement agreement so that if there's a non-performance here, it has some more serious consequences. Not like, I think in Commissioner Hall's project, at the end of something, the contractor pulled off and sort of said, see you later, talk to the developer. And that we're going to have those teeth in it. Well, the only, I'm concerned, I would not agree with their strikeout on the, I guess it's the third page where they are proposing to go to appropriately sized drainage, that I think we stay with a minimum of 24 inches. For the tin horns.
The only problem that you get into is that, Judge, the way I see it, is that, say if we have a 12-inch or a 16-inch horn in the road and we make them upgrade it to a 20.
Well, it's only if they damage it, number one. And number two is I've had a couple of commissioners tell me that our experience is that things under 24 inches tend to clog too easily.
Say there is an 18 or a 12 inch, which I don't know why there would be, but yeah.
We have them.
But just say if there is one. And they put a 24 in, all they'll have to do is berm it up a little bit so that it goes over. If they set it right back where the other one is. But did they replace any of those busted ones or did y'all have to replace them? They replaced them?
They stopped the project during that time and replaced them immediately. No, what we had to do is haul off the old horns. We had a truck available and a trailer. They would take the old horns out and put them on our trailer and we would put them in our lay down yard and they would put the new one in and all base. If they were running, and of course, most of the time when the cement trucks run, they run 24/7. And once they crushed one, what they would do, they would take a steel piece of plate and put over that horn where they could go ahead and make their deliveries. And then on a Saturday, they would replace the horn. The way it worked with me, it worked out best. It's just up, like I say, that's kind of Jed's decision and Robert's that, kind of how you work that, just as long as they replace them. But they always replace mine within just a few days in precinct 1. And if you want to allow them to end of the job, I know Robert got stung. I guess that was his decision. I don't know. But it's just that's the reason I keep going back to the commissioner. I think it's his decision.
Well, Mr. Allen, have you, even seen this agreement?
Not recently.
County attorney's not here either. I would move approval of the road use agreement for the Pretty Wind Project LLC with the modification to require minimum tin horn diameter for damage and replacement of 24 inches and subject to review and approval by our county attorney and our wind project attorney. So that give our two attorneys a chance to look at it, have the minimum 24 inches, and that's my motion. Okay. I would accept that.
That would be number 10. Jed?
So we have an amended motion, is there a second? There is a second. Okay. Any discussion? All in favor, say aye.
Aye.
Opposed? Okay. I will, Mr. Allen, I will do a second an amended red line with the changes we did by motion and send this to you and Mr. Hale after the meeting to review.
Okay.
Well, you're allowed to address the court on matters you sign up to speak on. And, you know, just personally, I think I know what your issue is. So why don't you just, I mean, we are not, the purpose of the discussion of the agreement is working on a legal document that we're going to try and get one step closer to execution or approval. So it's really not where you're going, but you're welcome. So go ahead and. Yeah, come.
I just want to mention, I guess, that I've dug into it a little bit, you know, the abatement agreements and the setbacks. And I mentioned before, I'm just concerned about the non-participants' residence setback. And I keep messing with this thing, trying to come up with some compromises. And I just keep coming back to a 2,500 foot setback from non-participating residences. And I think that's a minimum that's acceptable from a noise standpoint. Like I said before, not trying to damage the project or the go ahead of the project, but I do think we have people out there, I don't know how many, but that have residences and based on my personal experience being 2,500 feet from this one here on the edge of town, I think 2,500 feet's a reasonable number. It's not enough, but it's acceptable. And I think that's part of the compromise. As I understand it, there's a total of 8 wind generators that are within the 2,500 foot of non-participating residences, 8 out of the 63. And from what I can tell, looking at Google Earth, and from what, I don't know exactly which 8 it is, but I've got some other information that looks like you can kind of start identifying which 8 those are. And several of them around me look like could be relocated. without any significant difference in elevation. So that's what I'm requesting, is that we consider a 2,500 foot minimum setback from non-participating residences. The other thing I think that's still in question is what is the definition of a currently occupied residence? So we have people that have houses and cabins that don't live in them full-time, but they're houses, and I think that needs to be nailed down good with NG before any of the agreement is made. That's all I've got.
Call this special meeting, really two reasons. One was canvassing votes, and the other was to be able to discuss as a court the details of the abatement agreement. As we talked about a week ago, after our meeting a week ago, our abatement attorney, Mr. Allen, provided a shell agreement, one that his firm has used. I went through it and made some comments on red line that range from ministerial, names and dates and stuff, to substantive, to questions. And everybody's got a copy of that, and as does Mr. Allen and Mr. Hale. So we could, in a business environment, we do what we call a page flip and go through this a page at a time and see if there are any questions. But also that's a lot of talking. Now, Mr. Allen, do you have any alternative suggestions on the best way to tackle this?
That wouldn't be the normal way that we would go through it. There's a lot in it that is pretty straightforward and may be no questions on, but in order to avoid skipping over something, that's likely the most effective way.
Sir, I'm sorry to interrupt, but we cannot hear you.
Okay, is that any better?
Yes, sir.
Okay, so I had nothing on page one that was significant. Mr. Allen, is there anything on page one you want to point out? Any commissioners? Okay, flipping to page two. There's the concept throughout the document of the board and the governing body. Is there a reason not to call it the Commissioners Court, or is?
No, that's just, we'd switch that to commissioners. It may have been that this form that I sent y'all was done with a board instead of a commission. It's the same form. Sometimes it'll be for a county hospital board or something like that. That's probably why it says board there.
And on DE, the concept of county authorities, I was kind of at a loss on what we were supposed to put in that blank.
Generally, that would be you, the county judge, unless there is anyone in a specific precinct that you would rather have a precinct commissioner there being the one who has the opportunity to specifically interact with the company on. For example, if the road use agreement was incorporated into the tax abatement as opposed to a separate agreement, there we may specifically identify a commissioner as a person who's a point person because it's their precinct. With that being a separate agreement, generally we would make that be the county judge and that would be the individual who we'd have as a county authority.
On force majeure under F, I think we should either generically exclude public health emergencies or specifically exclude COVID. I mean, technically, we are under a public health emergency and have been since probably March, declared by the governor. And as things now stand, if I was on the other side of this, I could argue for an indefinite extension of all the deadlines in this agreement, as long as Governor Abbott had that public health emergency order out there. It does not seem to affect the activity of construction.
Yeah, we can limit that. Often the way we'll address it is by limiting it to a specific length of time. For example, if we wanted a force majeure not to extend past 6 months or 8 months or something like that, we occasionally will get some pushback on changing the force majeure, especially when there is an event of force majeure. They'd be afraid of, like you identified, if construction was limited and it caused it to take 2 years and they lost a year of their abatement. But we can start by eliminating that and then see what their response is. And then y'all can make that decision whether, if that's the last thing hanging out there, we can address it.
Yeah, let's try carving out the public health emergencies. I mean, the last time there were stop work and stay home orders, there was an exception list, almost as long as your document, and it specifically excluded utility workers and construction. So I just don't want this played against us. That's all I had on page 2. Commissioners, any other comments? Page 3. In 5, there's a section about construction, and it proposed a 24-month deadline. I was going to tighten that up to 12 because both applicants have talked like they'd be done within 6 to 9 months. And then contemplates a minimum project size in terms of megawatts. And that's probably might be a good idea. It keeps a lot of work for being done and then have a de minimis type result for our revenue and for the work invested. And my thoughts on that was for the Bluebonnet project, which is already fairly small, to have 100 megawatt minimum. They propose it as 103.5 megawatts, and I think 23 turbines. So basically, that's as is. And I just pulled a number out of the air in my thinking for the larger project that it was proposed at 300 megawatts to have a minimum of 250. But again, that's just off the cuff. Mr. Allen, any thoughts on either point of shortening the 24 months or the megawatt minimums?
We can go with the shorter time period. We may get some blowback on that. On the minimums, on the pretty one, the 250, I think they'd probably be okay with that. On the Bluebonnet, we may catch some pushback in that I think that would be losing a single turbine. If I'm remembering the size of turbines they were talking about, a lot of times that's what they're going to be looking for, is that wiggle room that if they get out there and there is some construction issue that wasn't anticipated and they lost a turbine, they don't want to have a situation where they lose the entire abatement over a single turbine. But the reason we put it there is to encourage them that if they've represented to us a project's going to be of a certain size, then it needs to be of a certain size. And that may be something all of y'all are specifically concerned about, especially with Bluebonnet, being the idea of you may not be that inclined to give an abatement for a 85 megawatt project.
Well, so if Bluebonnet's 103.5 and the turbine sizes are 4.8, I think, we could say 95 megawatts and that would protect from one turbine.
Yes, sir. The alternative on that would be, that's probably the best way. The other alternative would be having a minimum payment regardless of the number of megawatts they put in. Like if the commissioners decide to give an abatement and they want to give up $2,800 a megawatt or something, and you say minimum's $280,000 taxes, whether you put in 6 turbines or 20 turbines, just to encourage that size. But the 95 would be reasonable. It would put you around, losing 2 turbines. That gives some wiggle room. That doesn't happen very often, but just in case, for example, that would give some wiggle room if the commissioners do decide to address a setback. That may be a give and take, is if we do put in a setback in there and it may knock out a turbine, we've got to have those 2 provisions work together.
Pretty Farm to 250, and didn't they do 300?
Yeah, their proposal was 300. Okay. Other comments? This, at the top of the page, it talks about trying to hire local people, and there was a proposal that even if the local people were not qualified but could be trained in 72 hours of training, that they would be hired. I just proposed to make it 80. The logic for 80, that's 2 weeks. So if you could get somebody usable in 2 weeks local, then you do it. I don't think that's significant. Then we're trying to do things for the county, and I added something about how that if they work here, they have to do a substantial portion of the work in Mills County, and that if the employee doesn't reside in Mills County, then you don't count them as a full FTE. So if there's a requirement to have 5 people, and you have 5 people that live in, let's just say, Coryell County, that only counts for roughly 2 or 2.5 people. You still have to hire more people. It's a roundabout way to encourage local hiring. But Mr. Allen, have you seen other attempts at counties addressing this?
Yes, in a very similar way to that, yours is requiring full-time employees to be coming from the county. Another way we've occasionally included, and I don't see where it's in here, is requiring them to have a job fair in Mills County. For example, setting up at somewhere in Goldthwaite, or advertising the job specifically in the county. We could be very specific where we want those jobs advertised in the county. In our local goods and services plan, we could say something to the effect of there'll be at least 1 job fair held and advertised in the local paper, so that the folks that are actually there in Mills County know that the jobs are available, and have that opportunity. That's one way to do it.
I like that approach. Other thoughts, commissioners? Okay. So yeah, let's have a requirement to be, for the jobs to be advertised in the local newspaper and to have at least one job fair in Mills County. Yeah, yeah, I mean, but at least everybody knows about it, that, I mean, or potentially, you can't, you know, we get the same comments on the burn ban. They didn't know, well, it was just because it was in the paper, on the website, on the newspaper website, you know, you can't call everybody in the county and give them a personal. Flip it to page 4. Let's see, that's where we were. On abatement. I wanted to add, unless Mr. Allen tells us it's unnecessary, that the abatement requirement not only has a phrase in there that they have to remain in compliance with this agreement. Is that just unsaid, Jeff, or is there a problem with saying that?
There's no problem with saying it. It's one of those that we would imply, but it doesn't hurt to say it specifically.
And let's come back to the numbers separate from the language, if y'all are on board with that. So that's all I had on page 4. Anything else? Page 5, at the bottom, I wanted to try and eliminate the 48-hour advance notice requirement before we inspected anything. And then on the compliance agreement, solve the problem we have now with just getting a blanket letter saying we're in compliance. So to require that the compliance letter have adequate supporting detail that anybody that read it could figure it out. So, you know, like list, how many turbines, how many megawatts, how many employees, so on and so forth. And that gives you also something to audit against if you do go out to check. Mr. Allen, you see a problem with eliminating the 48 hours advance notice?
No, you know, there's no legal requirement for it. It's just one of those deals most of the companies want to have in because they want to know if somebody's coming, just to schedule to make sure the right employees are there. But if it's obviously preferable, if y'all can send a commissioner or employees out there to check on it without giving them opportunity to fix or hide anything. Not that we've ever had a problem with that, but there's no issue with it other than that they probably will want to put it back in and then we'll have to decide.
Sure, everything's negotiable.
A lot of times they have to look at their work schedule about, you know, it's hard for them just to show up on the job site.
Yeah. And that's usually what that's for.
Yeah, well, it still says we're gonna give them notice and do it in company of them. It's just to get rid of the specific time. Because then if you have the specific time, we're gonna get down into, is this business hours? What about weekends and holidays? And yeah. On page 6. Sure.
On the language on that reasonable time, instead of a specific time, reasonable time. And that way they'll respond to us within 24 hours or whatever else they might.
Yeah.
Depends on their work schedule, just reasonable
I-
time to inspect it.
I think I'd rather have a hard number of hours because they could say, well, so-and-so's sick and we, you know, or he's in Canada or wherever, and then it could be next week or next month. Yeah, that, then you're buying into an argument and lawsuit over over a word.
Reasonable time within 48 hours. What's wrong with that?
That's fine. Yeah. Okay. Reasonable time not to exceed 48.
Gotcha.
There, that covers both bases.
Everybody's happy with that, shouldn't be.
Okay, so let's do that, Mr. Allen. Anything else on page 5?
I don't see anything.
On page 6, this is a little change, but it's important. Down there in 11 on defaults, that the default is not only failure to pay the taxes, but any other amounts owed to the county. This is a backdoor approach to build it in the road use agreement.
What happens in that situation?
I'm sorry, sir, can you speak into the mic?
Okay, we will add to the definition of defaults, failure to pay taxes or any other amounts owed to the county. Commissioner Wright, I interrupted you.
That's fine, and my concern with that is that I go back to way we approach our abatement, whether it's going to be a 60-40 or whether it's going to be a pilot program. If it's under a pilot program, do we have any teeth to make them pay this amount if they default?
Well, that's part of the reason you use the word any other amount. So if they don't pay it, it's a default under the agreement, and a little later on, a default under the agreement will make all the taxes owed and payable.
But the court has given them 100% abatement on that pilot program.
In return for a payment of set dollar amounts. And that's why you have here too, ad valorem taxes or any other amounts owed to the county not being paid constitutes a default. So if the pilot payment is not made, that defaults the abatement agreement. That's where I'm trying to go with it.
Yeah, and what we can probably say in there too is put one of the self-serving, including but not limited to pilot payments, failure to make
That's a
annual
good idea.
amount.
It's specified that way under the pilot program. I think we'd have more teeth in making them, hold up to the agreement, as long as it states a pilot program.
Speaking of that, Mr. Allen, last week we talked about priority issues on defaults in payment of pilot, say in the event of a bankruptcy or a federal tax lien versus the status of a property tax claim. Did you have any additional guidance on that?
Not yet. I'm still looking to try and find something that's a clear answer. So I haven't got a clear answer yet. I'll try and get y'all one here with this week.
By clear answer, you mean no published cases on point, or are you finding things going both ways?
That's the main thing. Just to one where I can find it says specifically, this is the answer. I haven't seen anything that goes both ways. I see that we would be in the same position. I just want to make sure that we're as sure of that as possible.
That was even the concern with our county attorney on that situation. We need to clarify that. Yeah.
Okay, flipping to page 7. I was proposing to take out all the language about strikes and labor disputes. In my view, that wasn't really applicable in Texas. What is your position on this, Mr. Allen?
I don't have any problem with it coming out because from y'all's perspective, it's better not to. I mean, if we can get them to agree to remove all that, we're in a better position. I think if we send it across to them, it will find it back in there. But as an initial form for the sake of the county, we're in better shape not to have that stuff.
Okay, and just to digress at this point, one goal might be to come up with a consensus, not an approved agreement, but a consensus wording that then Mr. Allen could share with the companies in advance of our next meeting and even get feedback. So if there are issues to discuss, we've at least narrowed it down, sort of like we've done on the road use agreement. I had nothing on page 8. Well, there's a minor one at the bottom, but. Any other comments on page 8? Page 9, this has to do with the assignment and changes in ownership of the company and the project. And there's a attempt here I've made to, I guess, dequalify any assumption that would have people or entities that were in default on payments to other counties or other government entities and have at least the same level of experience and resources as the people we initially approved. It just seemed to me, Mr. Allen, that this gave the county almost no control over who our counterparty was after closing, and I was just trying to reinsert something.
No, and I'll send you across some specific assignee language. Often these agreements, because we are going to anticipate that this would be assigned, especially the Blue Bonnet one probably has a deep shot of getting assigned. I'll send you some language we use in leases. We'll probably get a little pushback on it, but you can share that with the commissioners where we limit to whom they can. I think at a minimum, the concept of saying the company, essentially what we call it is a qualified assignee, and saying that they can assign it to qualified assignees, but not non-qualified assignees. What we could do is define that as an entity that hasn't been in default with any of these agreements, things like that. We usually will define its credit worthiness and renewable energy experience. I'll send that language over to you.
Okay. Yeah, I don't think, I mean, on one of our projects, this isn't a big deal, but on the other one, I think it's highly likely it may change hands a few times. And you don't want to end up with an Enron or someone of that ilk as your counterparty and having to live and having no say in it.
Yeah, and that's pretty common. I mean, even, for example, there's 3 wind projects in Nolan County that were actually owned by Enron. So it happens. They still are actually functioning now, but it is very common that they get assigned. So to the extent that the commissioners can get some comfort with who it's being assigned to isn't a bad thing.
It's on page 9. Page 10, now this is the cross-reference to the road use agreement. The difference here is this actually is called road maintenance. This addresses the pre-construction and construction. It addresses the operation of the project. And as we have seen in our existing projects, the heavy equipment periodically is still in and out replacing things once the years after construction. And then looking even further ahead, the potential decommissioning and removal of the project, which could be, 20 to 50 years in the future. And this creates an obligation for road maintenance and repair during that entire period. It does reference the separate road use agreement, which we've earlier approved, and then talks about failure to perform under these road maintenance agreements, including this section that addresses way out in the future, is also a default under this agreement, which is where the teeth come in.
as a public road, how do we determine usage on it? In other words, we specified for this building project, but how do we go out and watch who's using that public road to determine who damaged it?
Well, are you talking legally or practically?
Practically, that you take Jed in his precinct, he's got milk trucks running. I have rock trucks running in my precinct. How do you determine which one damaged the road?
The heavy equipment used here, first of all, is going to generally be not licensed equipment to operate on a road. It'll be these potentially giant cranes.
Have concrete trucks that are licensed to use a highway. You'll have
The
haul trucks that bring in the blades and the
Right.
turbines itself. They're licensed on a highway.
if we can't pin it to them, you're right. But more than likely, I mean, just as living here in the county, and I believe as a commissioner, these projects, when work's being done on them. I mean, you can look on the skyline and see the cranes from, 10 miles off. And to the extent there's damage, either you'll know it or our citizens will know what caused it to have an opinion. And this gives us at least the entry to make that argument and get it collected.
Hopefully, because I had a damage on a road at 7 o'clock one night that somebody took out 2.5 feet of the caliche for nearly 30 feet long. And several of the residents drove by it and thought the county went out and dug that out. So, I mean, no reports.
But what's your point, Mike? Are you saying we shouldn't have a requirement like
Well,
this?
I just don't know how do we determine, how do we determine who made the damage? I mean,
If it's them do it, or if it's another contractor moving a big scraper, which they're moving them most of the time illegally anyway, because they don't get their permits, they don't get their heavy load permits, they just move them anyway. How can we determine that it's going to a wind project?
Well, are there any of those projects going on right now?
Oh, there's a lot of things being done right now, Jason, and they're running
Well, I'm just
these,
asking, no, I mean.
these heavy equipment, stuff like that. We can't stop that.
Okay, but
We can't enforce that.
if we don't have some language like this and we can determine who did it, we don't have any way to enforce it. So the language gives us something to enforce. We still have the problem that y'all are mentioning, knowing who did it, but that's a problem we have already.
Enforceable if we've had a weight officer working for the county.
And many people
can't get our,
are honest.
President, you're exactly right. If we had somebody to enforce it, but I don't know how we do as a commissioner, as a public road. We're there to maintain that public. Yeah, but
Solve a lot of your problem with them rock trucks.
yeah, and they're creating a lot of problems. Yeah, rock trucks are not though. They're in and out all the time and lots of damage, but I just don't know how we enforce it as a commissioner. I mean,
Well, I mean,
Maybe not this in depth, but we need to have something about road maintenance.
the only thing concerns me, a lot of it is can we cover all of our bases? I know we're trying to in this situation, but I don't know if we can cover all.
well, you can't is the honest answer. I mean,
Yes,
no
I know.
matter how hard, how many people work thinking of everything that can possibly happen, you're going to get surprised. So all we can do is the best we can do. And this gives us a way that if we can figure out if we know what happened, it gives us some teeth to go back as the court, not the individual commissioner, because this is talking about defaulting a tax abatement, to make a very credible threat, because all we really want is the road fixed. But
Simple as that.
You need a club sometimes, and this creates the club. If we can build a fact situation.
Okay.
If we don't have the club, you're nowhere.
On a bluff.
Or shot dice. I understand, Jed. But that's what I'm saying. I don't know how we cover it all.
Well, I
don't
mean,
know if we possibly do
this
all.
will not prevent road damage.
No.
And it will not determine.
No, I agree. I agree.
Way to try and address it if we can. Number 18 is something, Mr. Allen, I just added and threw in there, and it changed the numbers, but it's the concept of a decommissioning and renewal bond. And I have no idea what the amount should be. I put the deadline date on it is out in the 9th year of the project, because that you want it to happen, or I assume we do, before the abatement period ends, which would end after 10 years, and to have some sort of remediation and removal bond.
Yeah, and the amount, probably what we would put in, we can send across to them is a reference to the section of the Utilities Code, Chapter 301. That's the state law on removal securities. The leases, I don't think have better ones than that. It's a pretty standard amount. It's a net removal cost bond that they're required by state law now to have. And I don't think that that's an inappropriate thing to ask for here, because essentially what you as the commissioners are saying that you have to follow state law. And if you're not following our state law on decommissioning, then there needs to be local consequences as well.
Any other comments on page 10? Okay, page 11 is blank. Yeah, then we get down to the schedules. The schedules with this would be the legal listing of the properties in the reinvestment zone. That's what was published in the newspaper by Abstract. I believe would have a map in here. And then there's an Exhibit C, which is page 15, which talks about doing business locally. And I didn't have any comments there. Any court does. Well, is there anything else we missed or should talk about, Mr. Allen?
No, not on that agreement in that sense, other than just the blank, which is the money.
And that's then legal boilerplate that will let Mr. Allen refine or turn another copy. And if we can get some numbers in it, I would ask that he share it with the two applicants so that we will have feedback and go into our next meeting, which is where the agreements are actually scheduled for discussion and approval. We will have something in front of us concrete. Now, what's important then is the dollars and cents, and that's the two schedules I passed out. I ran one on the Pretty Wind project and one on Bluebonnet. Let's talk about Pretty. That's the big one, and I think we can scale Bluebonnet off it. The application that they made, each project made, showed their proposed investment amount and scale down over the 10-year period for depreciation based on their schedule. Then they proposed there was a request for a In the case of Pretty, a 60%, 40% abatement on taxes on those values. Then alternatively, they proposed a specific dollar amount of pilot payment. And that's the second column on the handout. And you can see at the bottom of it is a total. In the case of Pretty, it's, I'm going to round, 7.4 million. If you figure taxes at our current rate on the proposed, on the application amounts, which is an 8% depreciation, you see 15.3 million of all-in taxes. So the benefit to the developer of the abatement is 7.9 million. Next column shows, refigures the taxes, but based on what we have actually experienced in our depreciation on our existing projects, which is faster than 8%. And you can see there that the taxes that we would receive based on a 60-40% abatement wouldn't be the 7.4 million they're put in the application, but would more likely be 6.2 million. So the benefit to them then, it looks like it's $9 million. Then the applicant proposed a per megawatt charge, a pilot payment based on, rather than flat dollars per megawatt, of $2,480 per megawatt. And what I've run in the next box of columns is, okay, let's just look at that in a range of numbers from 2,500 per megawatt to 3,500 per megawatt, and run what the resulting pilots would be. And you can see a range of payments ranging from 7.5 million to 10.5 million over 10 years. And then the bottom line, you can see how that benefits the developer. It ranges from about a $7.8 million benefit, which is about where their initial pilot recommendation is, all the way up to about 5 million, 4.8 million, so a lesser amount. That's kind of the framework I thought that was useful to look at this. Everything, it's like buying a car. We have the sticker price, which is the application the developer has made to the county. We could just act on that, or we could come back with what we think or what we want. In talking to Mr. Allen, and that the range of numbers we have here is not past the realm of possibility. And the strategy would always be to come back with a number that would be in the 3.5 thousand per megawatt. And then it's going to turn into a negotiation. Mr. Allen, have I misstated?
No, sir, you have not. One thing to be aware of just between the two projects is it looks like what the company, if they're proposing the 2,400, the 24, whatever it was, 2,480, it's roughly that 60-40. That 60-40, there's nothing magical about it. That's not something that the commissioners are bound to look at. It's what I guess you would say a majority of the traditional tax abatements in the state have been 60-40s on renewable energy projects. That 2,400, 2,480 would be equivalent to a 60-40 on the Pretty project, but not necessarily on the Bluebonnet project. Just scale wise, it looks like the Bluebonnet project is a bit more per megawatt, about $150,000 more value per megawatt. And that may just be because of the scale of the project or the type of turbines and those sorts of things. So a 60-40 there would be a little different, probably closer to $2,800 a megawatt. But those are, like I said, that's kind of normal for lack of a better word. That's where a lot of abatements in the state come in, is at 60/40. And when we've done pilots, that's often, the number we latch it to, just in knowing we've done so many 60/40s. That is not something, again, that the commissioners are bound to. You can do whatever you want. But that's just kind of a little bit of background on that, but everything else.
My goal would be to do is to get as much as we possibly can for the county. And where we don't, we get something in return for it. So of the recent transactions you've seen, tell me the most you've seen somebody get on a per megawatt pilot.
It would probably be over the 3,000 per megawatt. A lot of that depends on the county itself, how much development has been in there, how important that sort of investment is to the county. For example, where we see lower per megawatt amounts are counties that maybe have not had this type of investment in it in the past, and they're wanting to get that large $300 million project on the books. And so we'll see a lower per megawatt amount. In counties that are heavily developed, it kind of goes to the whole point of, does this investment make a difference to the county that we should be incentivizing it with the abatement? Again, short answer to that is I need to go through the various ones we've done, but a little over 3,000 megawatts, probably the most we've seen anywhere, at least recently.
Well, my proposed strategy would be to, first of all, Mills County has some advantages to it from in these projects. We have a major transmission line already across the county. We have existing wind farms in the county, so there's no question about the amount of wind that's available. That rather than turn this into a negotiation in our consider and act next Monday, to include the $3,500 per megawatt in the Shell agreement that Mr. Allen shows to the Pretty Wind Project people this week, and see what, have it look at the negotiation of the number in context with the negotiation of the other terms of the agreement, and see what comes back. What are the other thoughts of the court?
Think that's too aggressive, or what's the court's pleasure? I mean, do we want the wind turbines here, or do we? I mean, I think we need to make it pretty strong on our stance here.
Well, first of all,
And to bend,
I believe, I mean, we're dealing in this case with sophisticated counterparties, with consultants and attorneys, and it's a business negotiation. So they put a number on the table, we put a number on the table, and it just leads to the next discussion. I mean, we saw that in the road use agreement with, although it took them, in that case, 60 days to come back. I think they will, because they understand the significance of the fact that we had to advertise that 30-day notice for the hearing on next Monday. And so if they don't come back, we can, if they postpone the hearing, that's going to put everything back another 30 days while we re-advertise it.
How do we determine which abatement we want to do? 60/40 pilot? We hadn't even decided that yet, or even come close to it on what numbers you give to them to come back at us at.
Well, on the pilot, I would propose going with the 3,500. The only reason I can see not to do the pilot is if we get high centered, if you will, on the lean priorities on the pilot program versus tax abatement. And then I would think we would need to do something less than 60-40 to make up for what we know is going to happen on the depreciation curve. Because if you look at that, there's a $1.2 million of value difference. Well, yeah, it looks like you lose by actual depreciation versus what they're telling us.
So we hadn't heard legally if we're protected under the pilot program versus the 60-40 yet.
That's what I just said. Well, but what we can do, or is what our attorney can do, and what counterparty are you dealing with, Mr. Allen?
That would be Mr. Gregson. He would be the.
Okay. Is we can just be upfront with their rep and say the county has not decided whether we are going with this or a pilot, but here's kind of the way we're looking at the two options, and that gets the numbers on the table without committing to either direction.
I think that's an excellent idea, Judge, what we should do.
Okay. Well, let's look at the Bluebonnet schedule. This one to me is more problematic because it came in asking for a 70% abatement for 10 years, which is to my view, that's out of market. And it's a small project, and it's 10 years. So, you know, just simple math, and I know it doesn't work that way, 60-40, 5 and 5, that's probably maybe the equivalent of 50% abatement, although there's some weighting toward the top end. 70% is 70%. So here we have a smaller project, less value to the county, less employment, more of a new developer, not somebody with a lot of, the individuals in the group have history, but as a company, they don't have the depth of history that you could point to with an Invenergy or an Engie. And so you have that risk layered on. And so it seems to me like with more uncertainty, you want to give away a little less. Mr. Allen, how have you seen other taxing entities approach looking at the more risky or smaller developers and projects versus the large ones?
And there hasn't been a lot of difference with them. Generally, the ones that have been smaller recently are solar projects, and they just address them similarly with pilots with a specific amount. Here, what they've proposed at 70% abatement, I don't think we've done that probably in, I don't know if we've ever done a 70% abatement for 10 years. If we had, it's been 15 or 20 years since we've done something like that. We've generally tried to treat most projects fairly similarly, but that one's for the commissioners to decide whether the risk there is worth it the same as the larger investment. I mean, you're looking at something that's a third of the investment of the other project. That does change the calculus of what you're going to be considering. Some of that we've done, like we showed on this one. I think that shell we gave y'all that had that fixed payment on it, that was one of the ways one county addressed it, was to confirm when there was some skepticism on whether they could build what they were saying they could build. They went in with a fixed payment saying like, if you're going to do this, we've got to make sure the county's going to get X dollars or we're not going to consider this. And then it would catch up. What that did was, of course, if they, for example, if Blue Bonnet only manages to build 50 megawatts and there's a fixed payment, their tax abatement percentage is much lower at that point because they have to pay that full amount. That was the way that we did it in another county, was that fixed payment to lock in some amount that the commissioners felt like, if we're going to commit to this, we need to have some specific amount coming in.
When this first came in back last spring, I told the representative of Bluebonnet that 70% was out of line and suggested they reduce it. And initially there was agreement to, and then it reversed itself a couple of months later and said, no, we just want to leave our initial application on the table and see what the county comes back to us with. So my sense is they expect us to do something different, but I'm still baffled as why the same consultant would submit at the same time 2 different applications with 2 different requests on them.
Judge, you check to these other counties, do all counties give abatements on some of these projects?
My experience is limited to Mills County. Let's ask our attorney. Did you hear the question, Mr. Allen?
Usually, I think there's one project in Nolan County that didn't get abatement. And that was a clerical error on the part of the company. Where we have seen abatements not be given on repowers, a lot of the companies on these older projects have asked for abatements to rebuild their projects. And I know Nolan County didn't give an abatement on that. And they still went forward with it. There are probably a handful of projects that did get built without abatements. We've seen, I'm going off the top of my head, I think there may have been one north of us that went forward with that one. It was a pretty small project. We've had some smaller solar projects that are built without abatements. That's where we've seen it mostly, is that smaller scale. We've seen them done without it. Repowers, we've seen them done without it. Most of the time, the larger projects do have them, especially, they've already been interacting with the schools because that's a large chunk of their taxes. That's the big killer. But it has been done. It's not common, but it has been done.
I know both of these projects have made a request for a abatement under, I think it's a 311 agreement or 313 or something, to the Goldthwaite School Board. I don't know about the other school districts.
Yeah, and that would be the 313. It's, as y'all know, that's the lion's share of ad valorem taxes. But
Did you hear Mr. Guerin's question?
no, I didn't.
Try again.
Wasn't Bluebonnet then, but the parent company of this, when it first started, Jason, 3 or 4 years ago, they said they weren't going to request a tax abatement.
When they had that meeting at Star, they said they weren't going to go in for a tax abatement. That was.
I've talked to William Kelsey, who is with Swift Current. He said they had acquired this project from somebody else. So was Kelsey the group that made that statement?
That's neither here nor there, but I mean, that's what we got in front of us. my opinion, I really like the pilot program. Just because I like to have a guaranteed number that we're gonna have, and we don't have to worry about what our depreciation is gonna be, or is it gonna be 8% or 11% or whatever. We're locked in, and this is our money we got, and that'll set the court and the county up for 10 years if we're gonna do that. At least 10 years, and it's looking out for the future. Yes, we know on a 60/40, we kind of know, but when we went into the last project, we thought we was going to do better than what we did. And so for the long term for Mills County, I think we ought to just be a little proactive on this part of it. Also, that worries me is maybe, 5 years down the road, is that Senate Bill 2 coming up and hitting us. I don't know. I don't know if it ever will this small of community. I know it will the big communities, but I do not know. And so I think this will be a little more, with the uncertainty of politics in Texas and in the nation, this would be a more certainty than what we know. But that's my 2 cents I want to throw in.
Yeah, I agree with you. I think the concern over creditor right priority is academically valid, but my approach would be I'd look at the probability of the 2 projects, and one of them, I mean, the deeper pockets you're dealing with and the bigger companies, the less likely that issue is than on the small companies where it might be more likely. And that's always a way to hedge your bet. I think this gives, let me just throw it open for a wrap-up discussion, but the purpose of this was to get input from our attorney. It was to give our attorney input. It was to talk among ourselves so everybody had more background on the information before it just pops up on a future agenda. But is there anything else we ought to talk about today? We've not taken any action.
Okay, so just to go back, I don't want to beat a dead horse, but if we go back to the contract itself, the abatement itself, is there current words that I don't see, I haven't found it, about setbacks in there?
I don't think the abatement agreement addresses anything other than there are references to the applications, and the applications from both companies include everything from number of turbines to turbine size to setbacks in their application. And if let me turn it over to Mr. Allen.
Yeah, right now, some of those exhibits are going to have the turbine count and those sorts of things on them. We don't have language specifically to setbacks in there. To have that be a requirement, I would recommend that we have a specific section in there, like the road maintenance, saying setbacks from occupied residents, where they would commit to it, how far they'll be back. And that would be at the commissioner's discretion where y'all want to say that. You don't have this is just a contractual agreement between you and them. So you would be contracting with them, not making any sort of ordinance or anything like that. It's just, if we're going to give you abatement, we want to protect residents in the county, making sure there's a setback that far. That would be the decision making.
Is there a way just to incorporate the application by reference and pull all of that in?
Could. I'd prefer it to be actually in there, though.
Okay.
There's no setbacks in this for the
No, there are no setbacks in there right now.
Yes.
that under road maintenance? I mean,
No, I don't think there's reference to setbacks in the road maintenance agreement. Well, we can pull together, then I just assumed it would be referenced back to the application. We can pull from the application the proposed setbacks and convert them to feet, because many of them are in terms of tip height plus a percent, or tip height plus meters. Get it to feet so we can understand it.
Like Mike said earlier, that we had a minimum on there. Maybe we ought to put a minimum if we want to do setbacks. I'm not saying the court wants to. I'm just saying if.
Well, I mean, the company, or at least Pretty, has proposed setbacks, and off the top of my head, I want to say it's 1,500 feet from all residences. Then there's a whole laundry list of things. There's setbacks from roads, and I want to say that.
Well, I've seen that in the application.
But we need to get it in the agreement as a schedule. Okay. Well, then I owe Jeff that schedule and the marked up road use agreement. What else, Commissioner Williams?
See it in this abatement.
Are we gonna put in 1,500 or 2,500 feet permanent width?
Well, 2,500 is
A lot.
over a
Half a
mile and a
mile.
half.
It's a lot. For any structure, I don't know how we do
Or, I
that.
mean, not a mile, a half a mile, over, 3/4 of a mile, so I said a mile and a half.
I'll ask you a question, you can.
Just a current resident.
That's the definition that's unknown. It says currently occupied residence. So that's kind of an unknown what that means, but it's not any structure. So that,
If you get down to any structure, that barn,
yeah, that's.
that
Barn that's been up since, since 1800s, it's still up. Is that a structure even though you don't use it? It's not on the tax roll?
Aluminum, yeah.
So if it's a structure on the tax roll, then maybe that could have teeth, but for any structure.
Well, I mean, but structures on the tax rolls, at least at my place, they include pens. It includes, goat sheds. I mean, they put it on the tax roll. Yeah. Yeah.
We all can. We all can.
I appreciate everybody's input. This was productive on moving along. I'm concerned about Monday. And Mr. Allen, while we have you here, if we do not have something that is actionable by Monday, can you guide us on where we go from here?
Yeah, I'll get y'all an answer on that. What we've done in the past is we've I can't think of the word. Not adjourned.
Test,
We
recessed.
Yes, we've recessed a meeting before for a couple days to, if there was like a specific issue and Judge, y'all wanted a more time to negotiate, we've just recessed as opposed to adjourn the meeting. So then it just picks up 2 days later and
We lost your sound, Jeff.
sorry. We've recessed meetings. That's an option we've done before in the past. I'll check to see if we would have to repost for the entire 30 days. Normally what happens is they get very anxious and they try and get something worked out before that meeting, which would be sometime this week. We'll try and
I
send
don't
this.
remember, excuse me, I don't remember all the rules, but I think there's only a certain time that you can recess.
It's 72 hours, I believe, under the.
So you're talking Thanksgiving here, so.
Right. I mean, so we're talking about recessing into Monday or Tuesday or Wednesday. I mean, and that's it.
Yeah, that's about all you'd have.
Jeff, your mic's not picking up.
Can you hear me now?
No sound.
I don't know. Mine's showing that it's,
Now, we lost probably the last 2 minutes of you.
oh, well, it was just stating that the recess would be the option. I'll see if we would have to completely repost the meeting or not to get it beyond that. Or mainly that we'd have to have 30 days or whether it can just be a normal posting requirement.
Okay. Well, I want to know what our options are as we go into this because there are still a lot of moving parts despite as much clarity as we can bring to the table.
Judge, the only other thing I wanted to add, I think the school board is discussing it tonight at their meeting.
Okay.
Not know any details.
That would actually
What
may
is their-
put us in a better negotiating position if the school board has done. Yes, if the school board's granted the agreement, it's going to be a little harder for them to walk away from reasonable requests from the county because the school taxes are much higher.
Pretty, do you know, does anybody know if Pretty's even discussed it at their school board?
No idea.
But the school board still meets.
Okay, well that, Jeff, I'll get with you later on this morning and send you some more papers.
Okay.
That includes our discussion. Commissioners' reports and requests. Commissioner Wright?
Agenda item number 2.
Yeah, well, you're right. I'm sorry. Thank you. It's lacking our treasurer. Let me see if Jason and I can explain this.
So it's a budget amendment. It's the insurance money we got from the 120H maintainer that went down during the fires out west of town. Insurance approved of it. It was, I don't know, 11,400 or something like that. And then the bill come in from RDO and it was 11,000. I didn't bring it, 11,300. So it's under the insurance bid, but that was last fiscal year.
So we got the insurance last year. We're getting the RDO bill this year.
They didn't get it in time. It come in like the week after the year, the year ended, the fiscal year ended. So all this is an amendment to pay that bill.
So what's the other side of the amendment? So we're going to have more money in equipment expense to cover the bill. And
I think there's like $50 to $100 left over to the good.
I understand that on a cash basis. I was just trying to think through the accounts involved.
And in his budget, in order to pay the insurance
Yeah,
cost
so-
out of this year.
In effect, we're increasing the.
Comes to my budget, but it's actually last year's money to pay for this year's bill.
Have to take it out of your budget, this year's budget, but out of the insurance last year, but yeah. And you
An
told us
audit,
that.
it's an audit issue. I don't quite understand all that, so.
I mean, it has to do with Trina closing out the books on last year.
So I'll make a motion that we approve the budget amendment for precinct 4 insurance repair on the 120H maintainer.
I'll second that. Any other discussion? All in favor, say aye.
Aye.
Okay, now, Commissioner Wright.
you order the burn flags through your office, or do we do it as a precinct? Always, in the past, Shay always ordered those burn van flags. Okay, good. That's what I was asking. I need some for the. It is worn out, and it was on the ground this morning, but you can't even.
We'll find what we have, and if we need more, we'll order them.
Check with your office when I leave this morning, see if you have one.
Recall, is it in the? Yeah, okay.
Also, we plugged the lights in for the Christmas for the senior citizen building. They're ready to turn on whenever you want them on. So they're there and ready to go. And that's one I usually work on every year is the senior citizen building. And we've been busy with a little road work, and that's all I have.
We're gonna be busy with road work. Last week, we worked 2 days, cut brush, but the hands was all Thursday and Friday, so we're focused on that. We're back to running rock today.
I've been doing some blading, doing a lot of road work ourselves, and I was gonna remind everybody, I don't know who Guy has visited with, but they are bringing in a high lift bucket or whatever to work on the Christmas lights on the courthouse. I know of about 10 of them that have fallen out. Those zip ties have finally deteriorated enough that they're falling out. Guy has repaired a lot of them with windows that can open, but the ones that don't, we have to have this lift. So we're also going to try to, I guess we're going to put up the reindeer on the front yard and all that, or the elk or whatever you want to call those things. Hopefully they'll make it through one more season before they deteriorate. So we'll see that. We're going to do that on Wednesday and Thursday. Am I right, Jed? So if anybody wants to come up and help. Yeah, we're.
Paid out of courthouse maintenance. There's money for it. Yeah, I think the lift is cost, I want to say between $1,500 and $1,800 for a week. Yeah, yeah.
Guy's been turning the lights on at night and looking for light bulbs that are out, so he has a list of which ones we can go replace while he's got the lift here. He's also going to Saturday, am I right? Saturday, the bee man is going to come in and attend to the beehives that are in the courthouse eaves while we have that lift here. So we don't have to kill a couple birds with one stone. So other than that, that's it.
Yeah, just, that was mostly what I was going to mention. The light check, we have 50 burned out bulbs in the Christmas lights. We've got 100 spares ready to go when the lift gets here. The lift is supposed to be here on the 18th. The beehive was coming down to, and that's all I have. So we have a motion and a second. All in favor, say aye. Aye. Meeting adjourned.